Hello, everyone. This is Jeff Ernst, Vice President of Sales and Marketing with Orange Tree Employment Screening. Thank you for joining today's call, our quarterly update, our first one in 2020 on compliance, regulation, and all of those legal sort of topics that impact our industry and the work that you do all day, every day. We are delighted to have our own Heidi Seaton, our Vice President of Legal and Compliance, as the keynote speaker today, and we will get to her remarks very shortly. In the meantime, I just have a couple of updates that I wanted to share with you relative to what's happening here at Orange Tree. We are focused on helping you do your job. We realize that companies are in a race to fill open positions, so we provide fast and easy background screening so you can hire quickly. We are focused on enabling the best brand experience for you, which means the best candidate experience for those that are going through the hiring process and that final stage in the background check. And we provide a background check process that can begin as fast as 3 seconds. And in our candidates, tens of thousands surveyed throughout each year tell us that it is easy, very easy to use. We recognize that your time matters. So we are very focused on ensuring that we do our job so you can do yours. There's record unemployment. While some candidates continue to move, and it looks like there's even a little movement as we exited 2019 and as we enter 2020, it's still a very difficult task for you all to fill all of the open positions that you have. And you need all of the help that you can, and relying upon your background screening organization, your partner, there at that last step in the process. It's critical that you can turn that job over to the screener, go about the next position, unearthing the next passive candidate. So we are very much aware of that and are focused on ensuring that we do our job so you can do yours. 2 primary examples. One, we take a lot of pride in verifications and having a very high close rate on verifications. And the second thing that we do, as a reminder to our existing clients, and for those of you who maybe not working with Orange Tree at this time, all of the great client care that we provide to our clients extends to your candidates. So they can call us. We welcome those phone calls, we welcome those outreaches, and the same 2-hour response and having the answers to their questions 9 out of 10 times. And that initial outreach extends to your candidates in addition to yourself. If you're not working with Orange Tree today, it's very easy to do so. 3 simple steps. Schedule an appointment so we can get aligned with your vision and your goals. We'll design a solution in step 2 to ensure that we understand the background program that is customized to exactly how you want it to be in alignment with your business policy. And finally, with a very minimal investment of your time, we can enable you to run your first background check very quickly. A new product offering for us, we've been talking about it for some time, and it continues to gain a lot of interest and a lot of traction from our clients. And we have changed the naming on it. We used to simply refer to our ability to help on a continual basis, your ability to get criminal activity and records and reports on your existing employee population. We had a nebulous term, and so now at this point we have branded that as Constant Connect. So in addition to being able to do your pre-hire check, a periodic check, we now offer you the ability to submit your pool of employees to Orange Tree, and we will provide near instantaneous updates relative to any sort of activity that you want to be aware of relative to your employee population. Another very popular offering, and it all is driven by the fact that you are looking for speed and execution in the background process. You're looking for the ability to place individuals into positions and into open shifts as quickly as possible. And that is our we refer to it as our instant value drug test program. It can be administered on site by trained staff, and the bottom line is, in addition to you could have people in jobs in minutes, you will likely save, and we'd be happy to show you the numbers predicated on your use case, 30 to 50% of your drug test costs. We have fully, for our existing clients who drug test with us, we have fully integrated the background and drug test ordering process. So your candidates now receive a single communication. They can schedule both. It's been very popular, very well received. It really streamlines the drug test process for your candidate, offloads you because now you don't have to do all of that work with the scheduling and whatnot. And all of the information, or at least these 7 steps that you see listed on the chart from the beginning, the registration process through the result and everything in between, is annotated in our system, so you know exactly where the candidate is and where that sample and that test is throughout the process. So if you want more information about that from Orange Tree, we'd welcome the opportunity to talk to you more about that. Finally, for those of you who aren't doing business with us today, a couple of notes on why you might consider doing so. We consider ourselves the no compromise, no surprise, no regret background screen provider in the market. From a no compromise perspective, we have the technology you need, the compliance you expect, and the client care that you deserve. There isn't a trade-off. You get all of these great things. It's become very obvious to me in my time in this industry that it can be difficult to know what a background screen provider is doing for you. We take a tremendous amount of pride. We work extensively to ensure that you know exactly what it is we're going to do, how we're going to do it, and we communicate all of the costs, all of the fees very much upfront and document that for you so you can plan accordingly and know exactly what you're getting. No surprises in doing business with Orange Tree. And finally, because we offer all that you need, and we do so in a transparent and a very visible fashion with you, we have customer relationships in which our clients refer to us, and we say this with also an amount of pride because it's easier said than done. It takes a lot of effort. We understand that. It's no small particular thing, but we really welcome the opportunity and want to be your teammate and trusted partner in the background screening business. So with that, I will turn it, before I do so, a couple of other things I should have mentioned. This call is being recorded, so just be aware of that. Handouts are available, should be available on your dashboard. They're already there for download. And then finally, you are welcome throughout the course of the presentation to ask questions, and we'll try to handle those online if we can. And if we're not able to answer a specific question, this given topic of compliance, sometimes it's unique and it makes the best sense for us to answer your question by doing so offline and really understanding the specifics so we can give you the answer that you deserve and makes the most sense for your specific situation. We will do that if we're not able to answer it on the call. So with that, I will turn it over to Heidi Seaton.
Thank you, Jeff. Hello, everyone. Good to talk to many of you again, and nice to meet those of you that are joining us here for the first time. My name is Heidi Seaton. As Jeff mentioned, I'm the VP of Legal and Compliance here at Orange Tree. I've been in the background screening industry in one role or another for, I think I'm actually officially in year 20 now. So I can't wait to get started on talking about compliance topics. And Jeff, I think I can try to advance this slide. Or not.
Let's try it again.
There we go, great, thank you. So I do have to stop at this screen and just remind everyone I'm not your lawyer. This is not legal advice, and I always recommend that you seek the advice of your own legal counsel for all matters of employment law as well as policy. So that said, The agenda today, we're going to talk first about what we're seeing at the state and local level. We'll talk about drug testing first, since most state legislative bodies are back in session now after the holiday break, and we're seeing some action there. We'll do a little wrap up and review from the end of 19 and then look forward to 2020, and really mostly what we're seeing as far as bills that are being introduced there. We have an update at the state, actually the territory level, regarding employer consideration of credit and credit history. We haven't had much news on that front lately, so we'll spend a little time on that topic. Just mostly talking about what that sort of legislation looks like. And then we'll move on to ban the box, sort of a recurring topic that we talk about every quarter. Give some updates on stuff that's happened since November and what we're seeing so far in 2020. And then on the federal side, we do have news about ban the box at the federal level. Very important news, especially for those of you that are federal contractors or subcontractors. We'll talk a little bit about some possible FCRA amendment action that we're seeing, and then we'll wrap up talking about some DOT or some topics for our DOT regulated employers. I have to apparently click 3 times. There we go. This slide, for those of you who attended last quarter, will look familiar. I know it's no fun, right? It feels like school, but I do want to just go through it quick again, because it's one of those concepts that I think until you've heard it the second or third or fourth time, it doesn't really quite click for you. And drug testing for employment it's different. It works a little bit different than how background screening works. So just a quick reminder about how it works. So drug testing laws are mostly for employers, unless you're DOT regulated, mostly a faction or a matter of state law. And at the state, you have mandatory laws, and those are laws that say an employer, if they drug test, must do it in this fashion. There are voluntary laws, and those are laws that say, hey, employer, you may elect to do drug testing, and then in that case, you should do it in this way. There's industry-specific drug testing laws, so there might be one set of laws for employers that talks about drug testing in general for employment, and then additional requirements if somebody's in a safety-sensitive position, or maybe a bus driving position. Those we're seeing a lot more regulatory movement there. And then there are layer on states may have unemployment compensation denial laws that say, hey, employer, if you're going to use a drug test result in order to deny an unemployment compensation claim, then you have to drug test in this manner. Same thing for workers' compensation. So if you're going to use a drug test as part of your denial of a workers' comp claim, the state may have rules about how you have to drug test. And then the topic that we all spend a lot of time thinking and worrying and hearing about if our employers are medical and recreational marijuana laws. And those are quite complicated. Those can vary a lot. They can cover, well-drafted ones cover what employers can and cannot do with marijuana drug test results and under what circumstances. Not so well-crafted marijuana laws from an employer standpoint are vague, or they aren't specific or clear. And so when we do talk in just a minute here, I promise, about some state law changes, these are the types of things that we see in states where there may already be a medical marijuana or recreational marijuana law. We see those laws getting updated or clarified. And then at the federal level, we've got the Controlled Substances Act that basically establishes what drugs are illegal or what drugs require prescriptions. And then that is the law then that we use for testing, for determining what drugs to test for under especially DOT regulations for safety sensitive positions, and then all the subcategories under the DOT, right? The Federal Motor Carrier Safety Administration, the FAA, the FTA, all of those sub-agencies also have drug testing regulations for individuals in positions that are regulated by those agencies. And then layer on case law, right? So don't forget, you'll have state law that gets passed, and then there will be some case law that gets layered over the top of it. That case then becomes part of the law. And by the way, that's why sometimes you see states going back and enacting or amending their laws, sometimes to make it clear that they that the case law went how the drafters intended the state law to go to, sometimes to change the state law so it more clearly reflects the outcome of case law. So a lot of stuff going on there. Just a quick, I promise I'm done. We'll move on to what's actually going on here. We're just to wrap up 2019, over 500 bills introduced, say our friends at Current Consulting Group. We did at the end of the year, we saw New Jersey passed or approved a constitutional amendment. So, sorry, approved voting on a constitutional amendment. So this will come up here, not actually until the general election for New Jersey. So we've got some time. I just wanted you to know, in New Jersey, they're contemplating a recreational marijuana law. It will be in the form of a constitutional amendment. So that means it has to wait for that vote in the general election. So we'll know probably then in November, the outcome in New Jersey. Just a little review here, reminder. I'm talking about some of these that we already talked about last time we met, but we've got some recent effective dates. So here, the beginning of January, Illinois recreational marijuana law, the Cannabis Regulation and Tax Act became effective. It applies to Illinois employer or an employer that has an employee, or to the employee that's in Illinois. It does allow employers to have reasonable drug and alcohol testing under their workplace drug testing policy. And employers also needn't accommodate an employee during being under the influence. Thanks, Jeff. Being under the influence or using while at work. Or while performing their job duties. So provided a little bit of protections here for employers. But in order for an employer to make an adverse decision about employment based on a marijuana drug test positive, they have to have a good faith belief that the employee was under the influence. And so the statute actually requires specific articulable symptoms. So employers, if you're wondering what that means, it means you should be training your Illinois employees on how to recognize symptoms of someone who's under the influence, and also how to document those symptoms. Employers also cannot discharge or not hire because of an individual's lawful use. So one of those classic rock and a hard place statutes for Illinois employers, in that it's recreational marijuana, so the marijuana is itself lawful, or use of marijuana is lawful, and so employers, if they're going to take that adverse action, have to have a good faith belief that the drug use was actually what resulted in the behavior that you're disciplining about. So that's just a reminder. Also a reminder on Nevada, another recreational marijuana law. This one also effective here at the beginning of January. It applies to pre-employment drug testing and post-employment drug testing within 30 days of hire. And it says an employer can't fail to hire based on a positive test for marijuana. Testing is still allowed. You can have it in the panel, but you can't fail to hire based on it. It carves out safety sensitive, right? So federal law very likely would preempt for DOT regulated positions, but states also have legislation about what positions are safety sensitive. So it does carve out safety sensitive positions from this prohibition. For positive results, so if you're testing for some reason within the first 30 days of employment, the employee has the right to submit to an additional screening test at their own expense to rebut those initial screening results. What does, still unknown at this point, right? What does submit to an additional screening test mean? Is that a new collection or a new screen of the original specimen? So moving on then to 2020. Again, our friends at Current Consulting are reporting already nearly 60 bills introduced coming out of 18 different states. That was a number from earlier this week, so there's likely to have been a handful more since then. And just bullet pointed here some of the topics that we're seeing in these bills that were introduced. So we've got workplace drug testing requirements. So these statutes, or these bills, I should say, are aimed at things like, requiring policies or requiring notice about policies, testing practices, specimen requirements, maybe broadening the types of specimens that are allowed to be tested. They touch on MRO, medical review office, policies, procedures, practices, and requirements, follow-up testing. Some of them talk about split specimens, things like that. We're seeing a fair amount of that. And again, most of these are, these workplace drug testing requirements bills that we're seeing are amending or modifying some statute that's already in existence. On the broad sort of topic of bills that we're seeing that provide employer protections, we are seeing things like employers making it clear that employers are not required to permit or use or to permit use or consumption or possession in the workplace. In one case, requiring workers' comp insurance carrier to cover the costs associated with medical marijuana use. That sounds lovely for employers, so we'll see if that one passes. Criminalizing drug test fraud, so that's an interesting approach. Again, in this preview, by the way, we haven't had any drug or any bills that have actually passed, right? So we're just keeping an eye on these bills as they go through. Still seeing a lot of marijuana decriminalization bills, legalization of medical marijuana or pilot programs, legalization of recreational marijuana is one we're seeing a lot of. Again, I mentioned earlier, industry-specific drug test statutes being introduced or bills being introduced. Lots of focus this year on driver testing, especially for hired vehicles. So I think they're probably focusing there on some of the vehicle ride sharing or hailing companies that are gaining population. Also, lots of action around driver testing for bus drivers. So interesting trend to watch there. And then around employee or applicant protections, we're seeing bills introduced that try to provide protections for qualified medical marijuana patients. For instance, prohibiting termination or not hiring for positive marijuana drug test. And then also clarifying off-duty legal activities and whether employees have protections there as well. So lots more of the same there in drug testing, and we'll be keeping an eye out on those as they move through all those local legislative processes. I mentioned when we were talking about the agenda today, we did have a territory that enacted limitations on use of credit for employment. We haven't seen that in a while. This is the first time we saw that. We've seen a law enacted in a while. So just to give people a reminder, right now we've got 10 states that have enacted limitations on employers' use of credit. So we've got California, Colorado, Connecticut, Hawaii, Illinois, Maryland, Nevada, Oregon, Vermont, and Washington. The District of Columbia has a statute, and then three large cities: Chicago, New York City, and Philadelphia. So Puerto Rico passed or enacted their Act to Protect Employees' Credit Information back in November. It had immediate effect, so no grace period there. It prohibits employers from refusing to hire or dismissing or taking other adverse action or discriminating against an employer or applicant based on information in a credit report or credit history. Employers are prohibited from either obtaining a credit report or also from verifying credit report information. And as with some of those other statutes, state and local statutes, there are sort of a list of exceptions, and every statute that I'm aware of on this topic has some sort of list. So employers just want to be careful to make sure if they are ordering credit reports for the employment decision that they are taking these exceptions into account. In Puerto Rico, the specific exceptions are for managerial positions, when the position is required by law, when the employer is required by law to be considering the credit history of the applicant, when the position has access to personal or financial information of others, when the position has access to trade secrets, and where the position is a fiduciary. Jumping in with ban the box at the local level. So again, just a reminder, this ban the box is that effort. It started a number of years ago now. It started as just removing the criminal history question from the employment application. So that was the box on the employment application is where that ban the box came from. But it's definitely broadened over time and includes now in some cases restricting when the employer can do the background checks. Or when the employer can make inquiries into criminal history, as well as creating additional obligations sometimes for employers. And it's really evolved now. Often this legislation is called fair chance legislation, but sometimes still referred to as ban the box. It was fairly quiet end of year with just a few local updates. We do have news at the federal level, but more on that later. So San Francisco, not new, but there's an update. So San Francisco has had statute on the books for some years now. They made a significant amendment in 2018 that required San Francisco employers to post information about fair chance hiring. The poster is the thing that updated or that changed here. So the poster was 4 pages and it was in, I think, 4 languages, and they now have it down to 2. So the contents are really, really similar. Not much change actually in the contents. They just shorten things up, more bullet points, fewer sentences, and they've cut it in half. So we do have that poster up on for our clients. It's up in our forums tab. The updated poster is there. If you need us to send it to you, we're happy to do that. But just remember, so it applies to any San Francisco employer with more than 5 employees. And by the way, that's with more than 5 employees anywhere. It applies to city contractors, subcontractors, and leaseholders. And it applies where to any position where the employee will work at least 8 hours a week in San Francisco. And under the ban the box, or under this fair chance statute in San Francisco, employers are prohibited from asking about the arrest or the conviction until after a conditional offer of employment. It also excludes certain records from consideration altogether. So employers are not allowed to consider arrest information that didn't lead to a conviction unless it's still pending. They can't be taking into consideration participation in a diversion or a deferral program. They shouldn't be looking at dismissed cases or expunged or otherwise invalidated cases. They can't consider juvenile case information. And then also they shouldn't be looking at infractions. So just an update there on San Francisco, not new ban the box there. We did have, oops, sorry, now I skipped it. Well, I'll just tell you about it. St. Louis, Missouri, so just a local ordinance that is pending, right? So that one actually has not started yet, but for St. Louis, it was approved by their city alderman here earlier this month. It's pending mayor's signature, and it applies only to city employers. City employers would be prohibited from asking about the criminal history question until after the interview. So more on that, I'm sure, next quarter when we talk again. Moving on, California privacy. Again, so far, California is the only state to have, or the first state to have enacted privacy law. I do expect to see other states following suit this year. We saw a lot of states attempting legislation last year, but nothing that passed. So I expect that'll happen again. Just a reminder that California statute was effective beginning of this year, but there was an amendment that extends for the first year. The CCPA will not apply to information collected about employees, and then there is also, as part of that amendment, the FCRA exemption. So eligibility information that would be used for FCR, Fair Credit Reporting Act background screening purpose is exempted from CCPA. Okay, moving on to a few federal topics. The Fair Chance Act. We talked last quarter, if not the one before, if not both, about legislation at the federal level, a sort of ban the box legislation and whether that would pass. And a version of it did. So effective at the end of December, December 20th, 2021. So we've got a little bit of time here. And it applies to federal agencies, including executive, legislative, judicial branches, cabinet agencies. The U.S. Postal Service does not apply, by the way, to judges, justices, or magistrates. I guess we get a free pass. And it applies to federal, civilian, and defense contractors, so including private employers. So that bullet point there is probably the one most interesting to at least some of our attendees today. If you have a federal contract or you're a federal subcontractor, this Ban the Box or Fair Chance Act will apply to you, and the effective date again, December of 2021. And it is sort of a traditional ban the box in that employers have to postpone asking the question, the criminal history question, or making any inquiries. So they also can't do the background check until the conditional offer is made. There are exceptions. Specifically, it doesn't apply to positions where a background check is required by law, but only, by the way, if the law requires consideration of criminal records before an offer is made. So just because you have something in a federal statute that says you have to do a background check, don't assume that this new statute won't apply. It will only apply if that federal statute says that you have to do the background check before the offer. And also exception for positions involving access to classified information or sensitive law enforcement or national security duties. So expect to hear about this. The General Services Administration and the Department of Defense were given 16 months to come up with or to actually implement regulations. So this act makes it law, but the regulations will really, I think, help employers to figure out how to implement it. So stand by for information or for regulatory information. It does include penalties for employers, so they should be aware of that. They're sort of increasing if there's more and more violations. And it's interesting too now for a national employer potentially subject to this federal law, also subject to state laws. It will be interesting to see if there's any sort of preemption issue there. In general, though, this federal law basically pushes that consideration of criminal history information question to the very end of the hiring process, so it probably would not be in conflict with state or local ban the box. Amendments to the FCRA. So this is pending. So this is just wanted to bring your attention to this HR Bill 3642. It's called Improving Credit Reporting for All Consumers Act. This is again at the federal law. The House is actually scheduled to take this up this week, so it'll be interesting to see how far it makes it. It is includes significant changes to, and this is quoting from the bill, fix the consumer report dispute process and to ban misleading and unfair consumer reporting practices. So I've looked at it. I'm hoping that the House does some work on it before they actually get to a voting process. I think it mostly just has drafting issues. I think based on what I'm reading in the bill, the drafters intended it to probably apply to national consumer reporting agencies or credit bureaus, but they weren't very clear about it. And so there is a chance that if passed as drafted, it could be affecting consumer reporting agencies or background screening companies as well. We did just this morning or yesterday, I guess, have a letter, an opposition letter that went from our PBSA, Professional Background Screening Association, lobbying the members to either make some changes or vote no. So we'll know soon, I think, whether or not that gets any action in the House. And then, of course, it would still have to make its way through the Senate if it does pass. So we'll keep an eye on that one. And then sort of our last couple topics here, especially of interest potentially for our DOT regulated employers. Just a reminder, we had a beginning of January effective date for the FMCSA Clearinghouse. So FMCSA is the Federal Motor Carrier Safety Administration. That sub-DOT entity had created this clearinghouse, and it's intended to be basically a database of information about violations of drug and alcohol testing programs for commercial driver's license holders. And then there's all sorts of rules about employers, medical review officers, SAPs, third-party administrators reporting violations of FMCSA regulations into the clearinghouse. And then employers are that have regulated CDL, FMCSA positions are required to query the clearinghouse for prospective employees, and then on an annual basis for current employees. So has also some requirements for state licensing agencies, and that did go into effect. They had a fairly rough rollout. It was bumpy. The site was down on the first day, but the site issues seem to be mostly resolved by the end of the week. So if you are a DOT regulated employer, if you have FMCSA regulated positions, you should if not already, haven't already, should be thinking about getting you yourself as an employer registered with FMCSA, talking to your drivers about getting registered with the FMCSA Clearinghouse, because the way the program works is that the employer initiates the query, the clearinghouse reaches out then to the driver for consent to do the query, and then once the driver gives consent, then the report goes back to the employer or back to the third-party administrator if your third-party administrator is running these services on your behalf. So there's a fair amount of administrative tasks for the employer, for the third-party administrator if you are going to be using a third-party administrator like Orange Tree to do the clearinghouse queries for you, and then also for the drivers. So lots to do there, but DOT regulated employers, FMCSA regulated employers, sorry, should definitely already be aware and should be, this should be on their radar if they don't already have it up and going. And then one last topic, just I talk about this with everyone because very often with drug testing, the way DOT drug testing goes is the way that non-regulated drug testing goes. So it's interesting. We did see, so under the DOT, each agency has a random and drug and random alcohol testing rate. And so the rate varies or can vary from one year to the next, and it's announced at the beginning of every year for every agency. And so we did see the new annual minimums were published, and they do represent a change from last year. So notably, the rate for the FMCSA testing went from 25% last year up to 50% last year, or this year, sorry, from 25, now they're up to 50%. That matches what we might now call a trend the FTA made last year. So the FTA was at 50% last year, but only 25% the year before. So it seems like for these safety sensitive positions, the driving positions, bus drivers, truckers, those higher random drug testing rates, by the way, are the result of higher drug testing, random drug test positives from the previous year. So that's the correlation there. Very interesting, and it just came out. So we just this week had final confirmation from all of the sub-agencies on what their rates would be. So that's what I have. Jeff, somehow I managed to click past the last slide.
Well, that's okay.
Sorry.
Not a problem at all. We can, while we figure out our slideware, if you will, what we can do. We do have a question, Heidi.
Okay.
I think this may have been back on the California page. The question, it's kind of a expression, and that is, can we talk about the part of the legislation law related to gathering information about an individual and selling that information to a third party?
Yeah, so the exceptions, so I think we're talking about the CCPA that we touched on, and the exceptions that allow the effective date to be delayed for employers are very specifically related only to information you, the employer, are going to use for an employment purpose. So if you're if you are intending to sell that information, then that 1 year exception very likely would not apply to you for your employees, right? So do be careful, right? Take a look at CCPA if you haven't already. The exceptions the two exceptions that I talk about are very specifically applicable to employment, the employment relationship, and data that is collected in order to like eligibility information or information collected about employees for the purpose of employing that person.
So Lori, if you're looking for additional clarification and would like to follow up with us, please feel free to do so, or others for that matter. I mean, Heidi, it may be a general comment, question, explanation to the audience here. Opening chart, 57 bills in 18 states. That's entering the year. A lot of legislative branches and bodies will get together here in the first half of 2020. What can our clients and individuals looking for updates from Orange Tree, what sort of communications can they expect from us, and or let's say knowledge from their client success partner, people within the organization, to help those individuals stay abreast of these important changes?
Sure. So we do post information about legislative changes in our blogs, and then we cover them in these sessions.
I'm just changing to the last page, Heidi.
Okay. Yep.
That's all.
I think too, very often, Jeff, one of the webinars that we do in addition to the quarterly compliance is usually we have a quarterly update just from one of our drug testing partners from Current Consulting or one of the others, and they very often also are doing a legislative update.
Okay, very good. I think at this point, Heidi, the questions have been answered. Thank you very much for this update. Just kind of reiterate, I know that we look to you to provide a quarterly update, which we try to keep it kind of the first month of each given quarter. Sometimes that varies. We also do have most of the months of the year a webinar on different topics, drug testing, and potentially a different compliance angle. So we like to keep you, our clients, prospects, aware of all of the important topics in the background screening industry and try to add content versus otherwise. And we're really interested in your view. If there are topics of interest to you, certain things that you'd like to learn more about in this format, different formats, please fill out a survey. Each of you will get an email following today's webinar. It'll provide a link so you could download the slides if you haven't already done so. Also allow you the ability to listen to any parts or the entirety of the webinar again. You can also forward that on to colleagues, etc. If there's other information you'd like to hear, we'd love to hear from you so we can continue to provide content that meets your needs and helps you do what you need to with your organizations each and every day. So with that, I thank you very much for your attendance. Heidi, thank you again for your time this afternoon. And I wish everyone a terrific day.
Thank you. Thanks, everyone.